Hi, everyone, and welcome back to Vetted, the show where we explore the systems, stories, and changemakers shaping veterans' lives today. At GenVets, we believe serving those who served begins with genuine listening, creating space for truth, context, and conversation that lead to real solutions. In this episode, I'm continuing my conversation series with Benjamin Pomerance from the New York State Division of Veterans Service Office of General Counsel, a name many of you will remember from our first discussion about the VA's duty to assist. That episode examined what the government owes the veteran, specifically how the VA must help develop claims and appeals in a fully and fair manner. Today, we're flipping the mirror. If the VA has duties to assist veterans, then veterans and their advocates also have duties to assist the VA to be accurate, transparent, and active participants in their own stories. Benjamin Pomerance is an attorney, advocate, and policy leader who's devoted his career to ensuring our nation's promises to veterans are kept in practice, not just on paper. He serves as Deputy Director for Program Development, designing and implementing programs that reach thousands across the state of New York. He's also represented clients before the Board of Veterans' Appeals and the U.S. Court of Appeals for Veterans' Claims. And he's one of those rare people who can make regulatory law sound like moral philosophy. Together, we talk about what a good claim really looks like, one that's fact-based, coherent, and ethically stewarded. We dig into how credibility and organization can make or break a case, why cooperation is as critical as evidence, and how advocates can honor both their clients and the process itself. Because in this arena, integrity isn't a buzzword. It's the currency that moves justice forward. Then, in the second half of the show, we turn to a different kind of responsibility, the one we all share when we talk about veterans in the public square. We examine a now infamous October 2025 Washington Post piece titled, "How Some Veterans Exploit the $193 billion VA Program Due to Lax Controls." It was framed as investigative journalism, but what it really revealed was a troubling lack of understanding about VA law, the rating schedule, and the legislative history behind conditions resulting from toxic exposures, Gulf War illnesses, and mental health injuries, and the perfectly logical explanation for increased claims rates over the last 25 years of data it analyzed, which it never seemed to link to 9/11/2001 or the deployments to the Middle East, leading to the exposures to toxins, chemicals, burn pits, to name a few. With health effects, we likely have only scratched the surface of understanding. Ironically, the Post motto is "Democracy dies in darkness." Well, all the Post did here was allow its own writers to publish the proof of its own concept. Benjamin and I talk about why this kind of reporting, whatever the intent, can harm veterans, the veteran community, fuel stigma, and undermine trust in a system already under strain. For me, addressing this story falls squarely under my own call to action, again, born from reflecting on why I began my mission to serve veterans and the military community. If you see something, say something. Whether you're a veteran filing a claim, an advocate helping veterans file claims, a journalist writing a story, or a citizen reading one, we all have a responsibility to speak up when the truth is being distorted. Because facts still matter, context still matters, and our veterans deserve both. The American public deserves better than what it got from the Post. Ignorance exploited as truth, disguised as narrative, packaged as journalism. So, as I continue this series on responsibilities, realities, and rebuttals, lean in, pay attention, and genuinely listen. Hello, Benjamin. It's so nice to welcome you back again to our second conversation together on Vetted. I'm really looking forward to continuing our conversation from the first one that was a few weeks ago now. We've been to, where were we? We were at NASDABA conference together, and the first conversation was such a success. Everybody was talking about it, and I almost felt like maybe I need to bring him on as my co-partner all the time, because we did well together. How do you think?
Yeah, glad to be back. Thank you, Jen. Thanks for having me back. Thanks to your listeners for saying good things about the last conversation that we had, which was not that long ago on the calendar. And yet, an awful lot has happened since we last spoke on this podcast.
That is indeed true, as we will talk about today. But I have to tell you, I think I suspected when we did do the first podcast that there would be more. I might have said that on the camera at the time, but I'm so glad that it's coming to fruition and that you agreed so kindly. It's an honor for me, if I'm being honest, to be able to have you on and to have these conversations with someone who is so well respected and seasoned in our community. And I really do appreciate you taking the time out of your day to do this. And because I do think that you have such experience and a wealth of knowledge in this field that will add to the depth of conversation that we need to have in this community, and to get out to veterans, advocates, service organizations, to the different agencies that are involved, because I think that there are people there who are constantly learning too. I know when I served at the agency level as well as the service organization level, I was always learning every day. I'm still always learning every day.
And same here.
Yes, and apparently there are news organizations that need to learn as well. It would seem that one of them in Washington that has the first name Washington, last name Post, needs to have some of its reporters take some of our classes, maybe.
It's an interesting time to be having this conversation, right? Because we're right on the heels of a Washington Post article that, frankly, to my surprise and to my horror, really assails the work of veterans advocates, and even more shockingly, veterans themselves, and acting as if veterans are gaming the system in ways that, in my 12 years of doing this work, I certainly have not seen.
Well, I've been doing it for 23 years now, and I've not only that, but before that, I was a journalist, and I'm so deeply offended by every bit of that piece that I don't even know where to start. I will be following up this podcast with something in writing. I think that would be more appropriate, because you know what? I'm happy to put it in writing, my position. And I think that there are many who would benefit from actual facts.
And this is true. And what really matters, and I think in this situation the most, is the collective amplification of voices of the people who actually are in this space and in this fight day in and day out, saying, this is not what we're seeing. Certainly, are there things in that article that contain kernels of truth, kernels of problems? Sure. Are there people in this system, like in any system on the planet, who might try and game the system? Sure. And I'm not going to say that there aren't. But certainly the impression that's being given here, that there are these overwhelming numbers of people doing it, that's not what we are seeing. And what really disturbs me the most, I think, in the entire article is the diminishing of certain types of injuries or illnesses related to military service. They're taking a swing, it seems like, at sleep apnea, at tinnitus, at eczema, at migraine headaches.
Well, let me stop you for a second because we'll come back to it. I want to spend some time and really dive deep into it and tell people what we're talking about so that they can go and find it themselves. Although I hesitate to give it more spotlight than it deserves. But at the same time, you know what? Um, part of part of journalism is putting light on the facts, and so I will shine light on this too because people need to know that what it is when they stumble upon it and maybe remember, oh, I heard about that and it's not true. So we'll come back to that, but I will say one last thing. This is shock journalism, and to your point, it is pulling out a couple things and making a headline of them as to, this is what we're seeing. This is how bad it is. This is what your tax dollars are going to. This is exactly what you've heard about. And it's absolutely not. And I won't, what did we talk about last time? If you see something, say something. I meant it in a different context at that point, but I will surely stand up for VA, for the board, for the um, Veterans Benefits Administration, for all of the service organizations, for the advocates, yes, for the lawyers, for everybody involved, and for the veterans who are doing it the right way when it comes to this, because their names are being besmirched. Now, last time we talked about the duties and the responsibilities in today's system of the Veterans Administration, the Veterans Benefits Administration, the duties to assist, the duties to notify under the law when it comes to helping develop claims and pursue appeals, and what those were. Today, I would like to discuss with you what the veterans and their advocates and service organizations, what are the responsibilities? And I think it's appropriate, also in line with this article, okay, this is actually fits perfectly in. What do we have to do as their advocates and those supporting them to help make sure that the system is being used the right way, that we don't have fraud, that we don't have abuse, neglect, waste? So what are your thoughts on this? How should we start?
I think where it starts is the foundation of the VA itself. Going back to the era of the Civil War, the VA was established without question by Congress and by President Lincoln to be a proclaimant, non adversarial system, meaning that the VA has certain unique obligations, like we talked about last time, in their duty to assist. Our job as advocates is to make certain that we are meeting that duty to assist by assisting veterans in our own way that utilizes the tools given to us. Case in point, every VA disability rating corresponds to a schedule of ratings that appears in Title 38 of the Code of Federal Regulations. So if you're an advocate and if you are preparing a claim that's going to go downrange to the VA, and that is a claim for radiculopathy, make certain that you are going into the Code of Federal Regulations, looking up the diagnostic code that pertains to radiculopathy. And if you're going to say, this veteran has radiculopathy that should be service connected and given I'll make up a number, 50% rating, make certain that you're raising that argument based on how the VA rates the disability of radiculopathy, and you're utilizing their own standards. Don't just put a loose, conclusory statement out there saying, this person has radiculopathy and it's bad. That's not helpful. That's not helping the client. That's not helping the VA either. And that's what leads to the backlog.
And it's important also to highlight here that that can't be changed. That's law. Those
That's law.
regulations are not something that you can convince VA hey, you should really look at something else besides what you've written in that 50% because my client is different. And
Right.
that goes for veterans too, a lot of whom are not represented. Because, as you said, it's a proclaimant system. They're not supposed to require help. It's supposed to be something where they can go to 38 CFR, blah, 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 and look at that rating and say, okay, this is what I need in order. I need to be able to show that my nerves, or this is how I feel, or I need to get my doctor to say X, Y, and Z. My records need to say this, and I need to show that it's been happening since service. I've received treatment since service, and I need my doctor to verify that, and it's shown by my medical records in service. And we put it all together, present this package to the VA with my claim form, and it'll be granted, right? You have,
Exactly.
what do you need when you file a claim? You need to know when you file that claim that you have what you need to have it granted. This is where things get sticky, wonky, whatever you want to call it. People just file and hope it sticks and hope that VA will help, or they might miss something, or yeah, okay, this guy did a lot, or this girl really, she tried real hard, she served for 25 years, she deserves it. That's not how it works.
It's all based on legal standards.
Right, you may be the most decorated, most deserving, but you still have to have a current disability that is something that started in service, or continuous symptoms, something that we can link back to service by a medical nexus.
And where I think things go off the rails, right, is when you have situations where they are, as you were saying, taking everything and throwing it against the wall and seeing what sticks. Now, it is true. Sometimes you will find situations where the service treatment records are blank. That's okay, right? Sometimes the military is not so good at record keeping for various reasons. So if the service medical records are blank, that does not mean it's game over. You still can win that claim. You can still pursue that claim successfully through private sector medical records, also through lay evidence, statements from people who can verify that yes, your injury did occur in military service, and or vouching for the severity of that injury or that illness. But what you don't want to
Your
do is
own
say,
statement, your own
exactly,
statement you
your
can
own
submit.
statement certainly counts.
You may be
Yeah.
credible enough in certain circumstances.
And it's possible to win a case, although the VA sometimes likes to argue this, but federal case law says you can win a case based solely on credible, keyword credible, lay
Mhm.
evidence in the complete absence of medical evidence. Again, folks at the VA will sometimes argue otherwise, but federal case law, Buchanan versus Nicholson, Jandro versus Nicholson, English versus Wilkie, I could go on, have
And
established
you're so much better at that than I am. That
the key takeaway, right, is that you can do this. The federal courts have said you can win a case based on lay evidence, but you're not supposed to be winning cases based on nothing, right? Throwing it against the wall and seeing what sticks. If you're going to file a claim with the VA, make certain that you are either providing the VA with evidence or you are directing the VA to where that evidence is. What I mean by that last statement, right, is the VA has that duty to assist, like we talked about last time. That includes the duty to track down federal records that are germane to the case and attach them to the case if they're going to help the claimant. But the VA's duty to assist does not begin until the claimant says, hey, I was stationed at Fort Drum in Watertown, New York with the 10th Mountain Division, and I was treated for medical issues while stationed on that military installation between 1999 and 2001. That gives the VA a starting point of reference. I always tell folks when I give trainings on these topics, Miss Cleo does not work for the VA. Okay, there's no clairvoyance there of whom I am aware. So if you want the VA to go and track down records on your behalf, you gotta tell the VA that there is a reasonable likelihood that these records exist and where to find them. And you know what? The VA opens that door right on their VA Form 21 526EZ, their main form for disability compensation, where they say something to the effect of, were you treated at any military medical installations or VA medical installations? If so, list them out here. I'm amazed how many people in a situation where those records could be crucial to winning the case don't put that information in the blank. That's not helping yourself if you're the veteran. That's not helping your client if you're the veteran's advocate. If you want the VA to engage in that duty to assist and to track those records down, fill out those boxes so the VA knows, okay, Sergeant Snuffy was there at Fort Drum between 99 and 2001. I have to go now and fulfill my duty to assist by tracking down those records. None of that stuff begins unless you tell the VA, hey, there's some stuff out there we think, go fetch, right? Until you do that, the VA does not have that obligation. The VA is not there to read your minds.
You have to be an active participant.
No, you're exactly right. You have to be engaged in your own claim. It can't be, okay, here it is, take care of it.
You have to be your own advocate as
Yes.
well. You have to help your advocate. You have to advocate for yourself. Because in this case, as long as I've been doing this, I do see VA doing a good job at asking for you in most cases. I mean,
Mhm.
again, when we talk about, are there slip ups, are there cases where
Absolutely.
things happen? Yes. But to me, those are actually really the exception to the rule, not what I see every day. The majority of cases, I see the ROs doing a good job at helping, and immediately those claims are filed, and I see those communications even before this relatively recent. We're doing the claims so fast. I see the development of them happening very, very fast. The communication starts instantly. What happens is, or was happening really before the internet and the speed of things being able to happen so quickly with electronic communications, was they'd send out a request in more antiquated systems, and it would take months for
Yeah,
people to actually walk down to the file rooms where there
I
were paper
recall those
files.
days. Yeah, and it
Oh,
was
I
not
do
fun.
too.
And we do see with VBMS, my complaint about technology is that if I go into VBMS, the Veterans Benefits Management System, right, and I'm looking at an electronic file for a veteran there, one thing that drives me up a wall is when I see whoever was working on that file from the VA labeling everything as
Yes,
general correspondence, as
yes,
opposed
yes,
to
yes.
using the categories that are going to help their rating team, okay, figure out, okay, like you were saying, Jen, this is lay evidence, this is medical evidence, this is an admin discharge issue, whatever, right? So in that situation, the old system of those separators with the hard copy files was an advantage, because now we're just
I
seeing
will
folks
tell
at the
you,
VA default to, it's all general correspondence, and the person who's actually
that's
doing the
got to
final
be
review on that
another
file, it's not good.
episode. That's got, because you know what? Maybe that's an idea to even put out there, is to color code like they used to, so that the
Yeah,
people who are just click on, so that at least then even within the correspondence, that that's something you're dealing with, because that it's actually a really big problem when you submit a medical opinion and it's labeled as correspondence. No,
right.
no, that's not correspondence, and it gets often overlooked by the raters and the board. I mean, that has truly happened a lot, where, we spend money to get what we need as evidence because we haven't been able to get the proper evidence, and it's
Yeah.
never considered. And then we
So,
have to
quick story
appeal, and yeah,
to show how severe this can get when things get mislabeled by the VA at the VA. I was working on a case, this is about 2 years ago now, where the veteran in question was homeless because the VA had stopped his benefits. Why did the VA stop his benefits? Because they claimed that he was a fugitive felon, that he was absconding from justice. Problem is, this man was neither a fugitive nor a felon. Yes, he did have criminal charges he was facing, but they were misdemeanor charges. By definition, he's not a felon. So I had to go to the county court where he was facing the charges and get a statement from the presiding judge saying, in effect, this man is not a felon. He has no felony charges. Submitted that to the VA. Nothing happened. And the man remained in a homeless shelter. I'm getting, steamed up now saying, come on, this is black and white. The county court said this person is not a felon. So I contact the VA public contact team, went through the various layers of supervisors there, finally reached somebody who actually looked behind the curtain, and they said, no, we have no such correspondence. I said, no, I submitted on this date, got a date stamped receipt from your electronic submission system. Go back and check again. You know where they found it? They found it hiding in the file, the electronic file, labeled as general correspondence. That's not general correspondence. General correspondence is the veteran writing in saying, how many more days will it take till I get my benefits? A statement from a presiding judge saying this person is not a felon, please restore their benefits to them that they never should have had stopped to begin with. That's not general correspondence. But VA labeled it that way, and it was literally stopping that veteran from having his benefits restarted and back paid because they still thought he was a fugitive felon.
On the lives of my children, I have that case on my desk right now.
Really?
It is not homeless. It's a debt recovery because
Okay.
fugitive felon status was put into place
Erroneously.
Erroneously.
Okay.
He turned himself in,
Mm-hmm.
and he was actively he was in jail in a different state, different county, but I'm dealing with a parole officer who feels so badly about what's happening
Yeah.
that it's just back and forth with.
Well, if things do get delayed, you might want to call the VA folks and say, do you have this statement from the parole officer sitting there in plain sight but mislabeled as general correspondence when it's not?
What are the odds? What are the odds that you would tell that story? And yes,
These things tend to happen
interesting.
more than once,
I know.
as you know. I mean, these mistakes do repeat themselves.
These are just a few examples of that, and I would love to go back and do something on that because it's interesting, those sorts of things. But back to our duties for the clients, talking about what we have a responsibility to do as advocates and service organizations, attorneys, and as if you're going at it on your own as a veteran, what you need to know when you are filing a claim today. One of the things that I think we'll talk about a little later that was pointed out in the article was that it's so much easier to present evidence under the new law, the Appeals Management Act. I actually don't think that's the case at all. But there are different no, I mean, you have to know exactly what you're doing, and there are time limits that were not the case under the legacy system. I mean, maybe there were, but they were absolutely not enforced in because you could pretty much do what you want. It's pro-claimant, pro-veteran, and they accepted things on napkins. My gosh. So one of the things that you have to know is the evidence that you can submit, the time limits that you can that you're restricted under, and what lanes that are best for you under the law.
I think part of it is thinking about it strategically, right? Do you want to say, okay, this is a higher level review. The VA has all the evidence they need from me. They should have gotten this right the first time. Is it legitimately that, not emotionally that? Because a lot of folks, oh, they have all the stuff. Do they really? Did you meet all the criteria that's laid out in the schedule of ratings for the medical condition for which you are pursuing the claim? If the answer is yes, fine, a higher level review is good, right? And it's supposed to be faster. Usually it is faster. And the VA is supposed to look at that and see if, in fact, they've made a mistake. I always like to request the informal conferences with the higher level reviews because that gives you a rare opportunity to actually have a dialogue with a member of the VA who is sitting in judgment over that case. I just had one on Monday of this week about a case where the VA calculated the effective date incorrectly. Okay, and I felt that a conversation, because it was kind of a complicated timeline, a conversation would be good so that way they could ask me any questions. And so at one point in the dialogue, the higher level reviewer said, I don't think you're right in your timeline calculation. They gave me his reasons why. And I was able to respond with the counterpoint of what he was missing. And he said, "Oh, I see that now. I wasn't picking up on that before. Yes, you're right. My hope is that now we'll get a decision back for that veteran that'll be in his favor." But that might not have happened if we didn't have the informal conference where that dialogue took place.
So the higher level review would be an appeal, though, once a rating decision has come down from the initial claim. Let's go back to the filing of the initial claim. We talked about what you need to do to file it, which is to file a claim with the evidence. Once you do that, VA
Mm-hmm.
may come back to you and ask for additional information. It's tempting sometimes to be like, no, I've already given you everything that you need. I'm not giving you anything more. I'm ignoring it, because you tend to get a lot of paperwork that comes back, and it seems like
A lot.
it's a lot. And I don't get it. I advise you really do take the time to take a look at what it is they're asking for. And a big one is the VA exams. If you're scheduled for a VA exam, you have to respond. You have to show up for that, because if you don't, it's a basis for them to deny the claim immediately, offhand, because that's part of this. You don't get to say no to that. They get now, if you submit, even if you submitted your own evidence that says you have it, here's where it is, they still get to ask the question and look at it themselves. You can argue later, even if they say you don't have it and you're angry and you're annoyed because you know you do. That's part of your argument, that your evidence is more substantial, more credible, more competent for whatever reason. That's part of what you have to go through in this system. It's so often the case these days, and that's again another podcast, and that will be a podcast. I promise we will have that conversation.
You're
But
exactly right in everything you're saying there. I agree wholeheartedly.
you have to address what they're doing and the process. This is simply part of the process. So show up, talk about it. If you can't make it because they have scheduled it at a time that doesn't work for you, they've only given you a week's notice, call and have it rescheduled. Oftentimes, it's not a big deal, but you have to communicate. It's all about communication with them. And I've not had a whole lot of experiences where they've been jerks about it. Now, one thing I will advise is that you stay on top of, if they've asked that you go out of the boundaries of what is a mile range, and you've said, I'm sorry, I'm not willing to travel outside of whatever it is, 20, 30 miles, and they say they can't do it, or there's not a physician that's within, be really careful and make sure that your file doesn't say, oh, they agreed and then they just didn't show up. I'm seeing a lot of that.
And part of that too on the communication piece is make certain that you are prepared as well to communicate with the examiner. Because, Jen, exactly like you're saying, that examiner holds an awful lot of authority. Yes, you may have your own evidence. It may be great. It may be from board certified specialists, but you know what? Now you're talking to VA's own expert. That they hired them. They have this person whom they are paying for to come in and do that exam for you. So even though it's a person working for company X, I won't use names, but company X, the VA is going to say, this is our expert. We're paying them money. And so we're going to give them, whether they say so or not, some additional credence when they look at that report. So don't go into that exam cold.
I wouldn't even go in empty handed. I would go in with my own evidence, because more often than not, they say that they've been given the file. But if you are an incredible deference, don't have your guard up, don't be annoyed or the PO that you have to be there,
Tempting though
whatever.
it may
But
be.
you know,
Right?
I had the greatest mentor and teacher of all time when I worked at PVA. I had many of them when I worked at PVA, but Jim Fischel, it was
Yeah.
my, Jim,
One of the
senior.
greats. Yeah.
I mean, I still call him all the time. And he tells his client, and he would tell me to make sure you tell the people go in, look, I don't know nothing about nothing, doc. I just am here to have you look at me and tell me what, because, nobody wants to be told, even though we all sort of do that when we go in. And it's not about white coat syndrome. It's not about, you just are there to be observed and to answer questions. Don't say too much because you can't take it back. You don't know what that doctor or that PA or nurse practitioner is thinking. Oftentimes they have 20 minutes, if that, to look at you, examine you, write the opinion. It just is the way it is. But if you go in and you're prepared to say, this is what I'm here for. Oh, by the way, this is from my treating physician. It's the medical opinion they provided, and I thought you might want to have it. That's all. Don't offer, this is what I have, and I am going to be service connected, and this is what I need, and this is why I need it. You're not there to prove anything. They're not your treating physician. They're not even the ones who are making a decision. They are not allowed to make a decision.
You will likely never see that person again in your life. It's a one-time deal.
And if they say in their report, if they tell you, oh, I'm going to hook you up, or I'm going to give you 30% or 40%, I'd be the first one to attack that, because it's against the law for them to make any legal conclusions, just like it's against the law for us to make medical conclusions.
And the other thing I always tell folks, too, about these exams, remember, it's not a closed book exam, meaning, in addition to your evidence, don't be shy about bringing in a notebook or a tablet or wherever you keep notes, where you write down the things you want to make certain that you tell the examiner before that exam ends. Because sometimes exams can be weird. Sometimes they can get stressful. Sometimes they can get downright traumatic, particularly if a mental health exam is going on and you're reliving some of the absolute worst days of your life. So that notebook or that tablet with your notes that you have prepared before the exam, okay, I'm not just saying prepare that day, but like a week before if you have the time, or 2 weeks before, you can refer back to that. That centers you. And so if you're feeling the emotions getting the best of you, you can look back at that notebook or that tablet and say, okay, here's the things that you have to know to understand the nature and the severity of my medical condition, right? And that returns you to a grounded place and a centered place where you can make certain that that information gets out. Because again, the examiner, like the VA, they're not clairvoyants. They cannot read your mind. If you don't say it, if you don't give it to them, they don't know it. You know your case, but they need to know your case. So don't be shy about coming in with those notes, because that can be a real important aspect of making certain the exam goes as well as it possibly can.
Now, that being said, just remember, if they're not as cooperative, if they're not as friendly, if they don't even make eye contact, let it go. Remember, they're not your treating physician. They don't make or break a case at the end of the day. They may affect what happens in that particular rating. I'm not going to lie about that. But that's why you don't give up when you get a rating decision that is denied. That's when you call a service officer. You get some help. Too many people, too many veterans get that, I tried, I got screwed, that's it, it's over. No, it's really not. And a lot of this is unfortunately based on a quick denial, a quick this, a quick that, because it is not about quality anymore. It's about quantity. And so I say that, and it may sound like, well, who says you can say that? I might hear that from VA, the statistics. That's what. And I could sit down and go through as many old of my cases and how many that I've successfully on that basis. We can do that all day long, but that's what. So don't give up, and don't think that you've just gotten screwed, because if you did, you know how many of your friends are in the same boat. You can't think that way.
Case in point, last week, I wrapped up a case that had been going on for 6 years, okay? 6 years. Lots of different appeals, lots of different cycles, lots of different bites at the apple, but we kept on fighting it, and now that we've won that case, that veteran does get retroactive pay all the way back for the past 6 years at the 80% disability compensation rate. So, exactly as Jen said, don't think the game is over. A lot of times the game is just beginning. And there are advocates out there who will walk that road with you and stand by your side and continue that fight until you reach victory. So don't feel like you have to walk that road alone either. You don't.
The Washington Post will tell you that that's all about gaming the
Yes.
system and that you're rewarded with a big fat check because you've apparently that's an easy thing. And
Yes.
I don't know why we would be doing it yet. But in any case,
Yeah.
so you have a duty to be patient. And I guess that's not actually a duty. It's something you're stuck with. But there are those of us who really do have the experience and will walk it with you, and listen to you be frustrated. But it's best for you to be frustrated with us and not those who honestly just it doesn't mean anything to them. You can complain, but why? We will be the ones who on shows like this and then use our abilities elsewhere to get that message across. And that's part of what I'm doing with my service organization and what my actual goal in life right now to do, as I've said before many times, is to make this difference. And if it's a slow road, it's a slow road. But I've got a big mouth, as I've said many times before, and Ben knows. Um,
That's a good
it's
thing.
scary.
There's nothing
Yeah,
wrong with that.
yeah. He says it. Many don't. All right. So we also, your duty is to respond and show up and keep fighting, because it isn't an easy road, but um, good things don't always come easy. So then we move once we get to the rating to the appeal process, and there are different roads under this AMA, this new law, and that is, as you started to say, the higher level review. You don't get to add new evidence there, so you need to know what your goal is and what your path is, what the abilities are, and you are wasting time and resources and taking away from and burdening the system if you don't know well what it is that you're doing when you appeal. So you need to understand before you file those papers and create additional work for people on the other end, which just makes it harder for everybody else. I don't say that lightly. Is it fair? Can we all complain that it's not as easy or proclaim it as they think it is, or that they intended it to be? I'm not even saying that they do it on purpose, because I really think, as being part of that time when everybody was trying to make it something different, nobody was, let's see if we can make it as complicated as we can so we can have less benefits go out. That is not what was happening back then. It just wasn't. But time and experience has shown that it's more than anyone really thought it was going to be.
To me, one reason why I always do that, it's so rare to have the chance to actually talk to the VA, right? Most of our advocacy is paper. It's writing. The chance for a verbal dialogue so rarely happens that I am always loath to pass that up, because that way, this week's case showed how this works. If they have questions, if the writing is still not doing it for them, they can say, hey, here's where we think this case goes off the rails. And we can respond in turn by saying, no, actually, it's not that, it's this, to try and bring them back on track. A quick word, too, about new and relevant evidence, thinking back to what Jen was saying earlier about the importance of not throwing things against the wall to see what sticks. That is extremely important when thinking about supplemental claims and new and relevant evidence, okay? Our duty as advocates is to make certain that what we are submitting with that kind of claim in that lane is indeed new and relevant. Not to say, here's 300 pages of stuff, we're going to give you all 300 and see if one page in there does the trick. That's not good advocacy. Every VA decision that you do not like, for any veteran out there, any veterans advocate out there, is implicitly asking a question. The question that it's asking you is, how do you prove us, the VA, incorrect in this particular area that we're using as the rationale to deny your claim? to be new and relevant. It has to be stuff the VA has not seen before, and it has to be on target with the reason why the VA denied that claim in the first place. So, for example, if it's a hearing loss claim and the VA denies that claim saying the veteran did not provide any evidence that they were exposed to acoustic trauma in the military, and therefore we can't service connect this condition, don't file a supplemental claim with 300 pages of audiology exams saying, my hearing is really bad. That's not why the VA denied the claim in the first place, right? They denied it because, in their estimation, you failed to show that your hearing loss was linked to acoustic trauma in the military. So, if you're going to get that overturned, you have to provide evidence that is relevant to that reason and show that, yes, you were exposed to acoustic trauma in the military. Anything beyond that is off topic and not relevant. So, read that VA decision. Even if you don't like it, read it anyway, because in that decision, they're going to give you the playbook. They're going to say, here is why we are denying this decision, or here is why we are giving you a 10% rating for this condition when you think you should be getting a 50% rating. And that rationale, that why, that's what you need to be attacking on appeal. Keep yourself confined within those guardrails. Otherwise, you're throwing stuff against the wall and seeing what sticks, and that's not good.
And to add on to that, in a lot of cases, they don't provide anything in their reasoning. And that in and of itself is an issue. They have to provide you a reason, a rationale, a clear understanding of why they did. So if they're providing you a rating decision and they're just saying denied, and they don't really provide a good reason, that's your appeal. That's what you say. You didn't explain this to me, and I deserve an answer. That's what it is that you are. And my advice in those cases, well, I'm actually curious to hear what you do in those cases. Do you file straight to a higher level review, or do you go to a supplemental on that higher level review?
I try and do a higher level review. I make the argument that under the 1990 precedent of Gilbert versus Derwinski, the VA has an obligation to provide adequate reasons and bases for every decision that they make. And if they fail to do so, that right away is grounds for the VA to take a second look and actually provide a clear and detailed rationale for their decision. And why we have that, not to get too deep into the weeds, but we have that because veterans have a constitutionally protected property right to their benefits, which means you cannot be divested of benefits that are rightfully yours without due process of law. Due process of law means adequate notice, that's your letter from the VA, and adequate opportunity to be heard, that's your chance to appeal. Well, it's not adequate notice if the VA sends you a conclusory statement saying, we are denying your claim. Why? Right? They have to answer the why. They have to show their work. Otherwise, they're falling short of that standard in Gilbert of having to provide adequate reasons and bases for why they are making the decision that they're making.
You're going to have to be guest speaker if I actually am starting to teach a veterans law class, and we'll be talking about that because that's just awesome. Okay,
It's a
and
great
then the
case.
last thing,
One of the best cases we have at our disposal.
it really is. It really is. But we're getting a little nerdy.
Yeah.
Now, lastly, it's the Board of Veterans Appeals, and I tend to reserve that after I've done one or two rounds because I think the other two are faster. And if we can get an answer, we get an answer. The board, you have three options for lanes. You can choose a hearing, you can choose evidence, or you can choose no evidence. No evidence is supposed to be 1 year. And that's a direct appeal. It's supposed to be done in under a year. That's the goal. Hearing, you can add evidence. There are different schools of thought on this. Some people think a hearing is a good way to get before a judge, and I personally don't, unless you have something extraordinary to show about yourself. I don't like having to. I think it's a judicial waste of resources when everybody is asking for an appeal. This is not a day in court. This is 15 minutes to explain what. If you haven't presented the evidence, then you haven't presented the evidence. There are things that a judge may need to see that you can't put on paper. A mental state, what a disability is doing to you, a colostomy bag, things that kind of shock the system, kind of thing. But just to tell them you're pissed off is not a good reason. To get to yell at a judge is not a good reason. And there are things that you can say I can't take back. There are things the judge can ask that I can't take back. I want to be able to control the narrative, and I can write a brief that may knock your socks off. But if I got to deal with what you've done in 15 minutes that takes the whole thing back, no bueno. So that's why I would. And yeah, so I'll leave it at that. But it also takes a year to 2 years generally to get to the board, and then the decision has to come out, and the transcripts and all of that jazz. So love the board because I think that they are, generally speaking, very intellectually at it. I think they give the best decisions. Really, I do. And then you get the Court of Appeals from there. So, but that's it. So I think we get any of your questions regarding the process, please send them in and we can look at that. But I'd like to spend, 10 minutes or so talking about why all of this that we've just talked about sort of is the reason why what we saw in this Washington Post article, how some veterans exploit 193 billion VA program due to lax controls. The Department of Veterans Affairs spends millions on dubious and even fraudulent disability benefits. Meanwhile, some deserving cases wait. This was written by Craig Whitlock, Lisa Ryan, and Caitlin Gilbert. Additional reporting by Nate Jones. The problem I have with this, among many, is the editorializing in a news article that claims to be news article. So much of this is the opinion of the authors that millions of the claims are for minor or treatable afflictions that rarely hinder employment, such as hair loss, jock itch, toenail fungus, eczema, hemorrhoids, benign skin growth, mundane conditions, the adjectives, mundane. And then they compare them to losing limbs during Afghanistan and Iraq. Inappropriate. It's not relevant to make a comparison like that. These benefits are something every veteran is entitled to. Period. End of sentence. It's not we should serve one group of veterans first. Every veteran is entitled to them the same. Now, the regulations are written the way they're written. The percentages are assigned the way they're assigned. And that is the way it is. If you don't like it, go to Congress and change it. But the way that they're being assigned and adjudicated at this point in time is not fraudulent. And what this article didn't address is all of those little things that are happening to people, antiquated rules that provide outsized benefits for some easily manageable ailments, a common breathing disorder.
Again, with the editorializing that this article keeps dropping back to. And, every condition out there is not so bad until you have it.
And have it in a cluster, which, by the way, is part of what an undiagnosed illness and cluster of syndromes from Iraq and Afghanistan, being exposed to burn pits, toxins, things that we don't understand. And to diminish what our veterans have been exposed to that we don't understand, shame on all of you, because it just reflects your lack of understanding and ignorance. Yes, ignorance about what those men and women have gone through.
No, I agree. I read this yesterday 3 times and grew more upset each time I read it. And then this morning I read it again and became upset all over again looking at it because there's so many fundamental flaws to it. And I think one of the worst is it overlooks a key point of why the disability compensation structure exists, which is Congress decided long ago that if you become injured or ill in defense of this nation, I don't care if that illness is the loss of a limb or sleep apnea or eczema or whatever else they want to talk about, you had that condition, and that condition is going to follow you perhaps for the rest of your life because you incurred that disability in the service to this nation. Period. Full stop. Therefore, the nation that you protected and defended has both a moral, yes, but even more importantly for this conversation, a legal obligation as defined by Congress going back an awfully long time to provide just compensation for that injury that you suffered in that service. If we want people to raise their right hand and go out and protect and defend this country, they need to know that this country has their back, not only when they're in uniform, but also, and in some ways, even more importantly, when they come back home, right? They don't need to be forgotten about after they take off that military uniform for the last time. And forgetting does not just mean you walk around saying, thank you for your service. That's all very nice. But not forgetting means they get what is rightfully theirs by virtue of their service and the sacrifices incurred in and caused by that service, to include the disabilities, whatever they may be, that are incurred by that service. And this article also overlooks how science works. Because, Jen, you and I know one thing can cause another. And federal law, thankfully, in Title 38 of the U.S. Code, accurately compensates for that by saying, look, if you have a condition that was proximately caused by something that began or worsened in your service, that secondary condition should be compensated as well. And the article takes aim at that by acting as if those conditions should not be compensated. And my question is, why shouldn't they? If but for the original condition that began in service, those secondary conditions, those chain reactions would not have taken place. So if the origin of all this stuff goes back to military service, again, there is that moral imperative and that legal obligation to provide that just compensation.
No, instead it says veterans advocates, for-profit companies, and VA itself encourage veterans to file as many claims as possible to milk the system. Documents and data obtained by the post spotlighted other obvious signs of waste and abuse, as well as internal awareness and tolerance of such problems. Bipartisan political indifference and a weak array of checks and balances have compounded the dysfunction. That's an editorial. That is not a news article. That was journalism 101.
And you and I share a journalism background, and I agree. If I had handed this in a news writing class assignment, they would have torn it up with a red pen, and rightfully so, because the author's own opinions are laced throughout this piece.
Embellished and bogus claims are clogging the system and making it harder for veterans with bona fide injuries to get the help they deserve, according to judges and prosecutors who have handled fraud cases. Okay, there are these cases that are being prosecuted. We have a fantastic IG right now. She's experienced. The former board of chairwoman of the board of Veterans Appeals. She's working, these reports are coming fast and furious, and they're good. She's well respected. So the job is being done. The investigations are happening. every paragraph in this is filled with these conclusory statements, and I can't help but I went and looked at the qualifications. I'm thinking, did these writers do that? Maybe I'm mistaken. Are they attorneys? Are they people who worked for the Veterans Administration or within the? They're not. They're not.
And what concerns me also when looking at some of the statements made is there's an assumption that I think is at the heart of a lot of this, that if a veteran is able to work, that they should not be receiving a high disability compensation rating. And there's so many problems with that. One, it's not what the law says. We'll start there. But two, from a societal perspective, if a veteran is able, in spite of their disabilities, even if they are severe disabilities, to find a way to continue to secure and maintain substantial gainful employment, I don't think society should be condemning that. I don't think we should be saying, well, you can pick or choose. You can get disability compensation from the VA for the injuries or illnesses incurred by your service, or you can work, but you can't do both, right? That's not what the law says, and that's not what I think the law should say either. Because if a veteran is able to continue engaging in that productive work life, more power to him, right? But it doesn't mean that they're not suffering day in and day out from the effects of those disabilities. One of the ones that they took a slam at here, it looked like, was irritable bowel syndrome. Okay, yes, there are people who work with irritable bowel syndrome, but you know what? That's not so pleasant. I don't wish that condition on anybody. And if they can prove to the VA's satisfaction that they are suffering from irritable bowel syndrome as a result of their military service, if they win that case, they should still be compensated for that significant change in their life that they suffered because of their military service. And if they're able to keep on working, fine. Again, more power to them. It does not mean their disability compensation should be taken away.
Here's another one. Lawmakers have approved a host of extra benefits for veterans who are 100% disabled, tacitly encouraging former service members to claim multiple ailments and inflate their rating. Is that what lawmakers are doing by approving that host of extra benefits? Is that what the PACT Act was when
Not
we
that I've seen.
acknowledged
Yeah.
when we were acknowledging the extra ailments that were coming from exposure to pesticides and to Agent Orange and other things that were coming
Toxic
out of
water
the?
at Camp Lejeune, ionizing radiation, the list goes on and on. Yeah.
I mean, and listen to this. I want all of the veterans to listen to what this is being said. I want you to understand and hear these words and understand when you hear what this is being said. In addition to receiving free medical care and prescription drugs, those permanently rated as 100% disabled pay nothing for dental treatment and don't have to repay federal student loans. Their spouses and children also get free health care and up to $60,000 for each college or trade school. In many states, 100% disabled vets are entitled to numerous other perks, including free license plates, complimentary hunting and fishing permits, and property tax deductions. You get perks, guys. Thanks for your service.
And one important aspect of this here, right, is that this debate is not new. I mean, we can go back in time. We can look at, for example, the presidential debates between Grover Cleveland and Benjamin Harrison. And there were fights about should veterans get as much as they are getting in terms of benefits. There was one situation during the Calvin Coolidge administration where he was looking at the VA structure, which, granted, was coming off of a very corrupt era under the Harding administration's VA secretary, Secretary Forbes, who was not the most honest guy on the planet. But, Calvin Coolidge made some comment, and I'll paraphrase here, that patriotism bought and paid for is not patriotism at all. Okay? That idea of bought and paid for was giving the impression that this was like a bonus. This was like, to use the article's word, a perk. I don't see it that way. And I've never seen the disability compensation structure or anything in the veterans benefit structure in that way. Because again, we as a nation depend upon people to raise their right hand and swear that oath to protect and defend and then carry out that oath. And when the country is saying to those people, your benefits that we're providing because you were disabled in some way, regardless of what that disability is in the line of service, is a perk, is too much, is gaming the system, is stuff that you shouldn't get as long as you're working. I do think that that influences adversely the willingness of future generations to serve. And that is concerning on multiple levels.
It is concerning, and for many reasons, as you're right, we already have a problem with service in this country. And well, we need to start to close, and I just wanted to say this, uh, as we do. The article called into question that service, and sort of why we do what we do. As I was a little bit shocked, as I've never, as a nonprofit advocate, someone who worked, I guess the government is coming under attack, the federal government. Didn't think I would see the day in doing what I'm doing, that I would have to explain myself or justify myself or give my reason as to why. And actually, I still really don't feel all that compelled, but I'm going to, because I want them to hear this and I want everyone else to hear this. My why started on 9/11. When those towers went down, the law firm I worked with, Carter, Ledyard, and Milburn, is on 2 Wall Street. They watched it happen. My law firm was the DC satellite office, and we were relatively close, as is the VA building, which is like right across the street and 1 block down, to the White House. We thought we were in danger. And so we were given the edict to go do as much good as you can to help. And for me, that was seeking out the Pro Bono Consortium, which I still volunteer for today. I credit them with starting me with it. I love all of them. And I'm, Steve Jordan, all of them, they're great people. They continue to inspire me. My why continued on Thanksgiving Day in 2016. And I wear this bracelet that my brother Mark had made for me. And I usually put it on my purse because I can't always wear it. And it has the name of my high school classmate, Scott Dayton, who gave his life for this country. He was the first service member killed in Syria. Thanksgiving Day, he gave his life, and his wife and his 2 kids don't have a dad anymore. His best friends don't have best friend anymore. You know what? He was a hunter and a fisher. He doesn't get that perk. He doesn't get all of the benefits that he might have had. But he raised his right hand. There's funny stories about how he joined the Navy, but he was only 10 months away from his 20 years of retirement. His son has applied to the Naval Academy this year, and I bet he's going to get in. The Naval Academy versus how Scott joined. But this is so offensive to me. He's why I do it, because he doesn't get his benefits. Other people are going to get theirs. Shame on all of you. Shame on all of you. By the way, his kids are coming up to lay the wreath on the tomb of the unknown soldier, next Friday. That'll be October 17th at 12:15. I'd love the reporters to come join me. It's a hell of a thing. Those are also the whys. Because all of them, those people didn't get to do this. They don't get to. But these people who came back, respect them. We all respect them. This is why. We need those people to keep raising their hand. God, I'm just disgusted by this. So yeah, come join me and that family who we all support, and the friends that come together to do it, and maybe think about donating to that scholarship fund.
Well, first off, thank you, Jen. Thanks. I knew some of that story, but not all of it, and thank you for sharing that. That's Profoundly moving.
Hey,
Not,
thank the Dayton family because
yeah,
they gave everything.
they did, as so many families have given
Yes.
everything. My why very indirectly began when I was quite young, about 5 or 6 years old. My mom took me to see my uncle Robert Needham preside over his courtroom in Otsego County, New York. Uncle Robert was a proud Marine. There are no other kinds of Marines, I've since learned. Proud Marine who served in combat
Facts.
in the Vietnam War and came home, had a challenging homecoming, but utilized his GI Bill to attend law school, became a lawyer, then a judge. Something about observing him in that court that day appealed to me, and in my squeaky 5-year-old's voice, as I always say, I announced I was going to be a judge like my uncle. He said, "You'll have to be a lawyer first," and I said, as 5-year-olds are wont to do, "Sure, I'll be that," or words to that effect. Fast forward a number of years, my uncle passed away not long after that day from a cancer that we now know was likely linked to his exposure to Agent Orange in Vietnam. Again, looking at those toxic substances, right? And I did decide to go to law school, and I was at a scholarship weekend for Albany Law School in upstate New York. Albany Law School is diagonally across the street from the Albany Stratton VA Medical Center, and I asked if the law school was doing anything with the VA hospital because I wanted to volunteer in my uncle's memory because he was my inspiration to go to law school. And I was told, no, the school was not. They hadn't really done anything in that kind of a partnership before. And my parents sort of half jokingly said, well, I guess you'll have to start something. The expression is fools rush in. So I rushed in. And my 1L year of law school, I founded Albany Law School's first ever veterans' rights pro bono project. I did not go to law school to be a veterans law attorney. I wanted to become the next Floyd Abrams and argue the next version of the Pentagon Papers case because, as somebody who did have a background in journalism, like you do, Jen, I was extremely concerned, as I still am today, it's a whole different topic, about where things were going with how the First Amendment was being treated by our courts. But I discovered once I founded this program how vast this field is, how deep the problems can be, and my biggest surprise was how overlooked the challenges can be. I had the impression, as I think many have the impression, that when a veteran comes home, the red carpet is rolled out, they're welcome back, and all the services are handed to them on a silver platter. That obviously is not what happens. If it did, we would not be having this conversation now and this podcast now. And each veteran whom I met, I know this sounds kind of cliche, but it's true. I saw this shade kind of my uncle, where I was a young kid when he passed away. We did not have any long, in-depth conversations about his service in the Marine Corps. And I've managed to piece a few things through the years back together about his military history, but still not enough to get a clear picture. But each time I met with a veteran, and this continues through the present day, I sort of think, okay, did my uncle go through something comparable to this? What supports, what structures, what advocates, what navigators were there for him when he came back? And that thought remains at the forefront of my mind day in and day out. And that's a crucial part of my why. The other part is I believe, and again, this may sound naive, but hopefully it's not too naive, that, as everyone loves to say in Veterans Day speeches, freedom is not free. There is a price to freedom. And part of that, and this is why I found the article that came out yesterday so upsetting, part of that is making certain that the people who come back home from protecting and defending that freedom are properly cared for. And again, that proper care does not mean, hey, thank you for your service, welcome back, now get on with your life. Proper care means to have that full measure of supportive services, whatever they may be, to include, yes, proper compensation for the injuries, the illnesses incurred in the midst of that service. Yes, provide even if that person is still securing and maintaining gainful employment because they've earned it. I'm not a veteran. I was not where they were. I did not do what they did. But I admire those who did it, and I believe this country has an obligation to properly care for them and to properly, yes, compensate them for what they've done, for how their life has changed, perhaps irreparably, because of what they've suffered as a result. And I think if we get away from that as a country, we are doing the veterans a disservice. We're doing the future of our military a disservice for the reasons I mentioned earlier, because they will look at how prior generations were treated and say, do I want to do this or not? And I think we do the country as a whole a harm by indicating that people are gaming a system that by and large they're not gaming. Are there bad actors out there? Yes, and I will not pretend there are not. Are there people out there in the so called advocacy space who are charlatans more than advocates? Again, yes. But is that the majority camp in either of those sides? Absolutely not, at least not based on anything I've seen in the past 12 years. So I believe this is a vital space. It is a noble space, and it is a space that needs to continue to exist as we go into the future.
Thank you for sharing that.
Well,
I
thanks. Thanks
really
again.
appreciate this conversation today, and I hope that people have learned something from it. And it shows me that we have so much more to talk about the next time. So,
For sure. And as always, Jen, thank you so much. Thank you for having this podcast, and thank you for getting the information out to those who have served and to their families and to those who advocate on their behalf. So thank you for your service.
oh, all right. Well, until next time, Ben, have a good
Till
one.
next time.